a police officer accused of being the middleman between criminal cartels and suspended Deputy Commissioner Shadrach Sibia just refused to testify at the Madlanga Commission. And what Justice Madlanga did next is absolutely brutal, because this witness filed a last-minute court application to block his own testimony, then showed up on camera and said he will not participate. So watch how Justice Madlanga destroyed both the witness and his lawyer who arrived late with pathetic excuses. Let me show you exactly what happened, because this is one of the most dramatic confrontations at the Madlanga Commission so far. Now bring the video on screen.
We were supposed to start at 9:30. We were all here at 9:30 except you. What went wrong or what happened?
Morning, Commissioners. Yeah. Commissioner, I profusely apologize for the 8 minutes delay in time on our side. Unfortunately, I had to start at the Higher Court, but I have communicated the fact that we are at the Higher Court so that we can have the necessary documentation being stamped and accepted by the Higher Court. And for that, with traffic and accreditation just to come in, that delayed us with that 8 minutes. I profusely apologize. That is not in any way a manner to disrespect the Commission.
You said something about communicating. What did you say? I think you said communicated. Or did I mishear?
Sorry, Commissioner, I didn't get that clear.
I thought somewhere in what you were saying, you said something about having communicated. Did I mishear?
Yes. Since at about 7 o'clock this morning, I've been in communication with the attorneys of the Commission, also in terms of exchange of documentation, where they were not having received necessary documentation.
Did that have anything to do with the possibility of you being late?
Yes, my colleague did communicate. He's just outside, but I will give you that. I can be able to give the details in terms of who exactly should communicate that we're running slightly late, or we might.
But in any event, Mr. Ngoato, you knew that you had to be here at 9:30. I do not understand why you would have had to go to the High Court personally. Surely you have other people in your law firm who could do that. And that's a very simple, attending to court and making sure that the matter is properly registered, assigned a case number and all that. That's a very minor, yes important, but very minor administrative issue, which could be done by anybody. It could even be done by administrative people who are not legally trained. Why it should take the owner of the firm, I assume you are the owner of your law firm, to go there and attend to this, it just does not make sense at all to me. For you to then make us wait for you, for something that could be done by someone else. For example, last week, you were there with please remind me, Mr. Malika. You were there with Mr. Malika. Why could Mr. Malika not attend to that? Or whoever else for that matter. This is totally unacceptable, totally unacceptable.
So Justice Madlanga just demolished this lawyer. He's asking the most obvious question. Why would the owner of the law firm personally go to the High Court to do a minor administrative task like getting documents stamped and registered when you have other lawyers and even admin staff who could do that? And he's making the point that this is unprofessional conduct because everyone else was ready at 9:30, the commissioners were there, the evidence leaders were there, everyone except the lawyer who decided to prioritize a simple admin task over appearing on time. And notice how the lawyer keeps making excuses. Oh, I communicated. Oh, my phone couldn't open PDFs. Oh, we're traveling in one car. But Madlanga is not having it. He shuts down every excuse. Now watch what happens next, because it gets even worse.
Why did you not communicate with Mr. Shaskalsen?
Mr. Commissioner, like I indicated, that I've been in contact with the attorneys.
Why did you not communicate with Mr. Shaskalsen?
I don't have Mr. Shaskalsen's direct number.
You were communicating with the Commission's attorneys. You could easily have gotten his number from them. That's not an excuse.
Commissioner, maybe if I'm given a chance to respond, then the Commissioner will appreciate.
Yes, go ahead, please. Go ahead.
Thank you. As of yesterday, Commissioner, I have 6 times called DM attorneys And I spoke to Mr. Mbao to give me the number of Geraldine Berger, who I know and have been introduced since the beginning of this proceedings to be the person, to be the contact person. For the entire day, I was not given those numbers. This morning, I spoke to the main director of DM Attorneys himself, and I indicated my disappointment that their law firm, since yesterday, I've been communicating with one of the officials just to get through to Geraldine Berger, and I could not get those details. I was quite very happy when I now deal with the main director, and we started exchanging since this morning. We're traveling with one car. When we were just about to arrive, and I was requested to have a copy of the High Court, I indicated to Mr. Mokhasho that for some reason since this morning, my phone cannot open PDF documents. So I'm waiting for Mr. Maleka to come outside court. I'm standing outside court so that I can send the necessary documentation to him. Unfortunately, in this particular instance, there was never any malice or any intention on our side to disrespect the commission. I've been up since 6 o'clock this morning dealing with this particular matter. We left our office 2 o'clock this morning.
Mr. Ngoato, I will say this, and I do not want us to engage any further on it. What you say from where I'm sitting are excuses that are totally unacceptable. I maintain what I said earlier, which is that knowing that you had to be here at 9:30, there was no reason for you to attend to a minor, yes, important administrative issue that could have been attended to by anybody.
Madlanga just called out all these excuses as exactly what they are, excuses that are totally unacceptable. The lawyer is blaming everyone else. Oh, I couldn't get phone numbers. Oh, my phone can't open PDFs. Oh, we're in one car. But the bottom line is, he knew he had to be at the commission at 9:30, and he chose to prioritize a minor task over being on time. So he's already showing up late and unprepared, making excuses, and now he's going to ask the commission for favors. Watch what happens.
Commissioner must appreciate and thank the commission for having granted us the postponement last week. And indeed, we definitely used off the time to the best of our ability as was granted since last week. However, since we started finalizing the documentation, certain things really cropped up and showed and changed the direction that we were taking, which therefore since necessitated this application. As it's commonly known, we are the creatures of instruction. It's our client instruction then to bring an urgent application in the High Court, purely and solely for two reasons. As the commission is in possession of the papers, I take that the papers might have been read, and apologize that they've been submitted to the commission almost on the 11th hour. The first reason, commission, is the same reason, one of the reasons that we mentioned last week, that the applicant, before he could even make his first written submission to the commission on the 17th of December, an interim report was already been issued, which we fully understand and correctly so in terms of section 10.4 of the terms of reference, that the commission is entitled to do so. But 2 days before he could even make his first written submission, an interim report has already been issued, which had recommendations and findings and recommendations against him. Unbeknown, and obviously we do not have access to that particular interim report, but just a day before our appearance on the 30th of January, which is last week, Friday, the state president publicly announced that he accepted the same report.
Here's what the lawyer is revealing. On December 17th, President Ramaphosa received the Madlanga Commission's interim report, and 2 days later, on December 19th, this witness was supposed to make his first written submission to the commission. But the president had already accepted the interim report, which apparently contains findings and recommendations against this witness. And then on January 29th, 1 day before the witness was scheduled to testify, on January 30th, Ramaphosa publicly announced he accepted the report and that this witness needs to be charged. So the lawyer is arguing, this is unfair. How can his client get a fair hearing when the president has already announced he should be charged before he even testified? And that's why they filed a high court interdict application this morning to try to block the testimony. Now, this is where it gets really interesting, because the commission is not buying this excuse. And eventually, the witness himself appears on camera and makes a shocking announcement.
My sincere apologies. Mr. Ngoato, can you please start from the beginning? I'm sorry.
In short, Honorable Commissioner, the witness will not participate.
Will not participate.
Will not participate.
Thank you.
Because for the reasons already given, if the commission orders him just to sit in and be available, he will sit in and be available, but he will definitely not participate.
Thank you.
Make no comment.
Thank you. As I said, I think we would like to hear the witness directly as well on this, because it's a very crucial issue. I do see witness F on screen. Witness F, have you been following? Have you heard what I've just said?
Good morning, Commissioner. I've been following you.
Good morning, Witness F. Mr. Ngoato has just said that you will not be participating, but I want to hear it from you, whether you also confirm that you will not participate.
I confirm, Commissioner.
But as you probably also heard, we as the Commission are not excusing you. We are not releasing you.
Mr. Ngoato, you and the witness may well be advised to look at Section 6 of the Commissions Act. Nothing precludes us commissioners or any one of us to ask questions of this witness. Whatever Mr. Chaskalson may have decided, whatever approach he may have decided to adopt, nothing precludes us from doing that, because we are the investigative body, the commissioners. And Section 6 says a witness who having been sworn, fails to answer fully and satisfactorily any question lawfully put to him. I want you to be mindful of that, whatever you advise the witness, as you're entitled to do, that whatever arrangement or whatever approach adopted by Mr. Chaskalson does not insulate him from questions from the commissioners, but it also doesn't insulate him from the legal obligation that arises from the Act to answer fully and satisfactorily questions that we lawfully put to him. I just wanted to point that out to you.
I appreciate it, Commissioner. Any answer given by the witness does not have to satisfy the commissioners. If no comment is equally what he wants to say, that is his answer.
I'm not opening a debate. You said something that I thought you seem to not be aware that his obligation is to answer fully and satisfactorily. Whether to say no comment is to answer fully and satisfactorily is a determination that we will have to make, is the simple point that I'm making to you. So I'm not asking you to comment, and I'm not inviting an engagement. I'm just pointing out that as you advise him, including if you are going to say to him, as you have suggested, he may choose to do, to say no comment, ultimately it's for us, the commissioners, to determine whether a no comment is to answer fully and satisfactorily questions that we have asked.
Madlanga just demolished that argument completely. He's making it crystal clear. Section 6 of the Act says a witness must answer fully and satisfactorily, and whether saying no comment counts as answering fully and satisfactorily is for the commissioners to decide, not the lawyer. And he emphasizes that nothing the evidence leader decided prevents the commissioners from asking their own questions, because they are the investigative body. So this witness cannot hide behind the evidence leader saying they won't ask questions, because the commissioners can ask whatever they want. And if the witness just says no comment to everything, the commission will decide if that's a criminal offense or not. This is brutal because Madlanga is boxing this witness and his lawyer into a corner. You either answer properly or face potential criminal charges. And all of this is happening because this police officer, who allegedly worked as a middleman for criminal cartels, doesn't want to testify now that the president has announced he should be charged. So let me explain what's really going on here, because this is a classic delay and obstruction tactic. Witness F got a postponement last week, claiming he needed more time to review 4,000 pages of documents. The commission gave him until today, February 3rd, but instead of preparing to testify, He filed a High Court interdict application this morning trying to block the entire testimony. His argument is that because President Ramaphosa accepted the interim report and announced he should be charged, he can't get a fair hearing. But here's the problem with that argument. The Madlanga Commission is an investigative body, not a criminal trial. Its job is to investigate allegations of corruption and criminal infiltration in the justice system and make recommendations. The actual criminal charges and trial come later. So the fact that the president accepted recommendations doesn't mean this witness can refuse to testify at the commission. He still has a legal obligation to appear and answer questions, and if he's innocent, this is his chance to clear his name and present his side of the story.